1981 bill was to recognize, as the Union Minister said, the historical fact that it was established by the Muslims of India. That we can't. That seems to have been the
I
intent
also
of
can't
the-
wish away. But
That
before
was the
that,
intent of
before
the-
that, she says that this was a part of our election manifesto. And your lordships, I leave it at that. Your lordships may realize the danger if the parliament were to be permitted to recognize 100 years history, hundreds of years of Lord history. I leave it at that, my lord.
That is Parliament's exclusive domain. We can't.
I
comment
am
on
happy.
that.
I'm very
The
happy.
policy underlying the
I am very
enactment of the
happy,
law.
Manoj.
That
I'm very
we-
happy. I'm arguing only university matters, but Parliament deals with many historical facts. Manoj.
Subject to-
I am very happy.
Subject to constitutional validity, of course.
Of course. But therefore, I didn't want to elaborate much on that. Manoj.
But what stands out is one of the honorable members, Mr. Banatwala, wanted a clarification to be inserted in the act that this is a minority institution.
Yes.
But there the honorable minister said, no, administration would be according to the statutes and the ordinances. Therefore, administration part cannot be left with a particular committee.
Yes, my lord. Coupled with the fact that Mr. Banatwala says that unless you give us administration,
It will
we
not
cannot
be so.
fall under 30.
Only establishment part was so to be recognized,
Yes.
but administration part was refused.
Was categorically refused.
But then when was for the first time the institution was recognized by the government as a minority institution?
This is never recognized.
It's one thing is very clear. The intent behind 81 amendment was to recognize and give it as a minority institution and to do away with the whatever the reasoning was given. The attempt was to modify the reasoning given or make the statute modify the statute so that the reasoning given in Basha's case is not applicable. Yes.
Is this not that?
No,
After half an hour also it rings?
No.
No, no.
administration is concerned, yes, Mr. Banatwala did say that please make an amendment saying its administration is in the Muslims. That the government did not agree. But what they said, administration is already provided in the statute. So
Statute, the statute, yes, yes.
all statutes will provide for administration. Even today, even after the 2004 Act, the Education Act, each statute will provide for administration. That's not the administration, the word, mainly because the statute provides for administration is not cannot lead to a finding whether it's a minority or a majority.
No, Lord, I would risk.
That will, if we accept that argument, that if administration is provided by the statute and this itself is going to be a ground to decide whether its institution is a minority or majority or non-minority institution, will lead to difficulty.
I'll just, my Lord, respectfully, my Lord,
How
answer.
can that be? Mainly because administration is provided by the statute. That is not may not be the criteria.
Kindly.
We have to find out who are the people actually administering it,
Correct.
or in terms of the statute, who are the people entitled to.
I bow down, my Lord. Your lordships will have to examine the statute as it stood in 1981, and in that context, my Lord, examine the request of Mr. Banatwala that right now it is not our administration, and therefore we are unable to fall within the second part of Article 30, Sub-Article 1. That establishment, yes, but not administered by us. You clarify that we are administering also. She says no. Act will govern. And the amendment.
Whether the government was right or not, that's a separate issue. But the fact of the matter is the government also, when they were saying it's a minority institution, they very well knew of the requirements of Article 31. They felt that the administration is also with the minority.
No, my Lord.
Because otherwise they will not say it's a minority institution.
No, my Lord, they didn't. I'm sorry.
Mr. Solicitor, they were very well aware the two requirements for minority institution, establish and administer.
Correct, my Lord.
To say that when they moved the amendment and made an open statement in the House of the Parliament saying it's a minority institution, they were not aware that administer is also one of the requirements will be little difficult to accept. Maybe they may be right or wrong. It's a separate question.
Yes, my lord, maybe they consciously, my lord, did that. All right, we satisfy you. We recognize the historical fact. What they have done is recognizing the historical fact according to their history, without, my lord, or rather omitting the history which I have shown. That one after the other, they started, my lord, giving up their rights. If there was no concept of a right, but their demands, their insistence, that this we will not accept, all right, we give up. This we will not accept, all right, we give up. That's not taken care of. But they say that we recognize a fact in history that this is what happened. As my lord, I'll not reread it. But everyone was clear, including the government, but especially Mr. Banatwala, that unless you give it, and what was, my lord, the amendment suggested? Amendment was administration to be given to Muslims. That was within inverted comma. And the minister says, no, it will be as per the act. If as per the act, your lordship finds that it was Muslim administration, that's a separate thing. But if that is so,
Solicitor, to really conceptualize your argument, because I think we've heard you on this, your argument is that Article 30 incorporates twin tests: establishment and administration. Basha came to the conclusion that, well, one, Aligarh Muslim University was not established by Muslims, though it does recognize the history of Anglo-Oriental College, etc., because it says it was established by statute. That's the first limb of Basha. And inasmuch as that it was established by statute, it has not been established by a Muslim minority. That's the first limb of Basha. Second, Basha says on the review of the act that it is not administered by the Muslim minority. The 1981 amendment, according to you, was intended to recognize the historical fact of the establishment of Aligarh Muslim University and brought about that change both in terms of the preamble and in terms of the definition of the expression university. But the second limb of Basha, which was that it has to be administered by the minority, there was no alteration to the existing statutory provisions in relation to administration. And which was in fact noticed by Mr. Banatwala that you cannot, in that sense, though he didn't put it in that word, in those words, that you cannot override Basha unless you deal with both the establishment and the administration tests. And you had left the administration intact, and therefore it would not, in that sense, still fall within the ambit of 30.
then Basha still stands, would stand.
And
That's what he.
That's your contention.
And, my lord, I'll just add
And
one
perhaps,
thing.
therefore, your contention is that the 1981 Act did not take away the basis of Basha, because you could have taken away the basis of Basha by not merely
Establishment,
recognizing,
but
but administration as well. That's your
Plus-
submission.
plus,
We'll have
my
to hear the other side in response. I think now we've understood it conceptually.
Another
That's what
aspect.
there's a
Lord,
hard
Basha
issue to hear them.
Basha also recognizes,
I think that is
the-
really the submission.
Basha
We'll have to
also
hear.
recognizes the fact that your rights, if at all there were any pre-constitution, were extinguished. Because you started giving up those demands one after the other. And therefore, there was no concept of a minority or minority rights in 1920. It was just a bargain between me and the government. Some of them, my lord, said that we will not accept your bargain. We will say that no, we want to have this framework. But those who were in charge, my lord, Mr. Sefi and led by them, my lord, they say, all right, we give up this, we give up this. Government says, no, it would be full control of the government. All right, let it be government control, etc. My lord, I have given. Basha recognizes that. Lord, the parliamentary debate does not.
All right. Anything now?
Lord,
what's
next,
the-
my lord, next. Please come to page, volume 2A. I'll take only 10 minutes, my lord. 2B, I'm sorry, my lord, 2B. At page 50 to 54. I'm not going to read, but I just want to give, my lord, the illustrations.
Please, Mr. Solicitor.
50, my lord.
2B,
To
page 50 to
554. How, my lord, this factum of founding or factum of establishing is always recognized whenever the legislature wants to recognize by the legislature itself, and how it is recognized. Even administration is recognized by statute. Therefore, I say 1920, the curtain falls, the statute takes over. Lord, please see Sam Higginbottom University of Agriculture. My Lord, it is, my Lord, University for Anglo-Indians. Please see, my Lord, the title at page 551, my Lords. Volume 2B, page 51. Lordship gets, my Lord. I'll just, my Lord, the small font, my Lord. This is, my Lord, the preamble of the Act. An act to establish and incorporate a teaching, research and extension university with a view to upgrade and reconstitute the existing Sam Higginbottom Institute of Agriculture, Technology and Sciences, deemed to be University Allahabad, established and administered by the Ecumenical Minority Christian Society, namely so and so. This is how, my Lord, establishment, the historical fact of establishment and administration is statutorily recognized. Please see, my Lord, same at the foot of the page, same university, the jurisdiction. Save as otherwise provided, I'm sorry. Because the argument of other side was on a wrong reading of Bhasha, that all these universities will go as minority institutions. No, it will not go. Legislation has conferred upon it the minority character. Please see the jurisdiction. Jurisdiction of the university, save as otherwise provided by or under this act, the limits of the area within which the university shall exercise its powers shall be whole of Uttar Pradesh, with its headquarters at Allahabad, with powers to associate any Christian minority institution within its jurisdiction. The predominant purpose of minority character of the institution is statutorily recognized. My Lord, kindly come to page 52. Era University, Lucknow.
Page
52, next page, my Lord. Era University, Lucknow. Lord, the other side would say that these were institutions incorporated after the National Minority Commission Act. That is true. But wherever the legislature has thought fit to record the historical fact and give it a statutory color, they have provided. So that's my purpose. And this is, my Lord, in response to their submission that if Bhasha is right, that once you are incorporated, you can never be a minority institution. That reading of Bhasha is wrong. Bhasha does not say so. Bhasha is only a sui generis, fact-specific judgment examining the Aligarh Muslim University. Please come to B, the Era University, Lucknow. An act to establish and incorporate a teaching university sponsored by Era Educational Trust, duly established and administered by the members of Muslim minority community. Then, my Lord, trust is also accordingly defined. I will not, my Lord, take your Lordship's time. Please come to next page. All these acts, my Lord, the power, not only statutory historical fact of founding is recorded, accepted statutorily, administration is given. Please see, my Lord, Tirthankar Mahavir University. An act to establish an act to establish and incorporate, I'm sorry,
Yes.
an act to establish and incorporate a Jain minority teaching university sponsored by Tirthankar Mahavir Institute of Management and Technology Society, Moradabad, Uttar Pradesh. The 9 also, Lord, kindly see only the highlight, underline part. Nothing in this section shall be deemed to prevent the university from making appropriate provisions for reservation of persons belonging to minority community in the post and recruitment of the employees and reservation of seats for admission in any course of study in the university which cannot exceed more than 50%. Lord, I'm not duplicating, but the same provision in Northeast Adventist University. This is, my Lord, a Christian minority institute, university, established by an act. Then, my Lord, please come, my Lord, only last example, my Lord, I would like to give. 4I, my Lord, volume 4I. I'm on Alia University, page 1375.
Same volume,
No,
1375.
no, 4I. Same volume, 1345.
7.5.
My Lord, 1375, yes, ma'am.
This is 4I.
4I. Aliyah University, my Lord.
Volume 4I.
Yeah, 4I.
Page.
Volume 4I.
Page
1375.
1375.
75.
Thank you.
This is a West Bengal legislature, my Lord. Your Lordship would have the title West Bengal Act of 2007, my Lord. Please see, my Lord, the preamble. The second part, whereas. Does your Lordship get, my Lord? Whereas it is expedient to upgrade Calcutta Madrasa College, erstwhile Madrasa Aliyah, one of the oldest institutions of higher learning and culture in India, and to that end, to establish and incorporate a teaching university at Kolkata, to dissolve Calcutta Madrasa College, a government madrasa college, and to transfer to and vest in the said university all properties and rights of the said college. Now, please see, my Lord, 3.3. 1378, my Lord. Section 3, subsection 3. 1378. Lordship gets, my Lord. But please see, this is important, very important, my Lord. Whenever the legislature wants, legislature does this. 3, subsection 3. The character of the university shall be same as that of Calcutta Madrasa College, erstwhile Madrasa Aliyah, declared as such with a minorities development and welfare of Madrasa Education Department, Government of West Bengal notification and dated so and so. Statutorily provided, historical fact recorded, and the same status and character statutorily recognized. Now, my Lord, I come to my last argument. But please come to what is this university, my Lord? Volume 2A. I'm sorry, 2B, my Lord. Page 12.
Page
12. And my Lord, I would, this is my last submission, but very important submission, my Lord. I take only 10 to 15 minutes and then, my Lord, I am done. Lord, what would be the, well, there are two things I want to highlight. A, why this issue arose and we are before your lordships. And two, see the consequences if your lordships were to interfere and your lordships are not in appeal against Basha. What would be the consequence of an institution which the Constituent Assembly declared to be a institution of national importance. Please come to, my lord, page 12. This is broadly what this university is about. This is one of the finest university of the country, my lords. But it has, my lord, total, my lord, I have given, my lord, the chart, total number of entities, then number of faculties. Please see faculties, my lord. Agricultural science, management studies, arts, engineering and technology, theology, medicine, social science, life science, Unani medicine, law, science, international studies, etc., etc., etc. My lord, large number of, my lord, subjects, my lord, are being taught. Please come to, my lord, I will not read everything. Please come to page 15, number of colleges. There are 8 colleges affiliated. And the next is number of centers. They have centers, my lord, all over the countries. But I am not right now addressing your lordships on that because that's not the question. But TMFI says, for the purpose of deciding minority, the unit is state. Muslims are not minority in Kashmir. What would happen, my lord, if they have a learning center in Kashmir? That's not, my lord, the right now, my lord, question, and therefore I am reserving that argument. Please see number of centers, my lord. They have 23 centers all across the country. Then number of academies. They have 3 academies. Number of institutes, number of schools, and the number of students, my lord. Please come to para 16, page 16, bottom. How many students are studying? 27,619. Correct, my lord? It does not include polytechnic students because they are getting diplomas. These are all degree holders. Now, why this problem arose? Lord, please take the Constitution of India, my lord, for a while. Article 15. But I need not highlight that equality is heart, soul, and blood of the Constitution of India. After, my lord, we became free from the British regime. Article 15, my lord. Your lordship gets 15, sub-article 1. The state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Lord, nobody can be discriminated against. Hindus, Muslims, Sikhs, everyone are at par. Now, earlier, an argument used to be raised that there is an exception to this under sub-article 5, which is not accepted. Lord, your lordships have said that sub-article 5 is not an exception, but another facet of equality. Because the government, the nation, the country wanted scheduled caste, scheduled tribes, socially and educationally backward classes also to be at par, and therefore sub-article 5, my lord, was introduced. Nothing in this article or in subclause G of clause 1 of article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribes, insofar as such special provision relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state. Please underline this, my lord. Other than the minority educational institutions referred to in clause 1, article 13. Meaning thereby, your lordships have the mandate of equality under article 15, sub-article 1. Another facet of equality for scheduled caste, scheduled tribes, and socially and educationally backward classes. And the last part of sub-article 5 is an exception to that equality clause. And therefore, your lordship's test to decide whether a particular institute or university is a minority will have to be a very strict test. My lord, this amendment is after TMA Pi and PA Inamdar. They do not take note of this fact, my lord. Where your lordships have said that 15.5 is an extension of the doctrine of equality because scheduled caste, scheduled tribe, SEBCs, they are not equals. They are required to be brought at par with rest of the citizens irrespective of the religion. But exception is minority is accepted, meaning thereby, and this is, my lord, crucial.
Doesn't this then amendment also accept the reasoning given in TMA 5 that the minorities are entitled to have reservation in their institutions?
Aided institutions. Yes, my lord, it does say.
Doesn't it then give that recognition?
Yes. But, my lord, the question is, now, if Aligarh Muslim University, having these many faculties, law, commerce, medicine, engineering, this, that, and others, and one of the finest university recognized as a national importance, institution of national importance by the constitution at the original framing of the constitution, would not have reservation for SC, ST, and socially, economically backward classes. And they would have at least 50% reservation for Muslim candidates. So, a deserving candidate of a scheduled caste or a scheduled tribe or a socially and educationally backward class person would not have the reservation, but an Lord, person having all Lord economic everything, my lord, at his command, based on religion, would have my lord reservation, and that led to filing of petitions before the Allahabad High Court. My lord, that is what I wanted to show. My lord, please come to volume 3E, page 20. Page 19, I'm sorry, not 20. Volume 3E. But your lordships would also examine from the point of view of social justice and equality. One interpretation.
So that choice was made by the Constitution, right? When they brought in the 93rd Amendment.
I'm saying taste would be very rigorous. That's all I'm saying.
They introduced it. This was a constitutional policy now, which is given
This
for
was
us.
challenged.
And if you have an Article 30 institution, you are accepted from the provisions
Correct.
of
Correct.
all these provisions.
Lord, my respect, I'm not saying that your lordships may decide dehorse that exception. I am saying that 15.1 is equality clause, 15.5 is extended equality clause, and the last part of 15.5 is an
Excludes minority.
exception. Therefore, your lordship test, the test which my lords would adopt would be very, very strict test, because it would be SC, ST, SEBCs or Muslims or any linguistic minority or any other minority. So social justice, my lord, would be a very, very determining factor in your lordship's decision making. That's my respectful submission.
All right. Yes. Anything else, Mr.
My
Sultan?
lord, only 5 minutes. My lord, why, my lord, this came? My lord, why the petitions came? They introduced in PG Medical College this reservation. Page 34, my lord, say directly.
Which volume are you referring?
Page 34, my lord, volume 3E, 3 capital E. This is
Yes, Mr. Solicitor.
Lord, please come to page 34
Of,
volume 3E. This reservation came in 2005. That led to filing of petitions. And your lordships would, my lord, bear in mind, it's almost an admitted position between the parties that even without a reservation, approximately 70 to 80% students are Muslims. I'm not on religion. It's a very, very serious phenomenon. An institution of national importance declared by the Constitution must reflect, my lord, the national structure. Without reservation, this is the position.
And across the board in all universities.
Correct, my lord. It is happening. All universities have students from every walk of life. Please
do
see,
we
my lord,
have-
now 34.
Do we have the data with regard to that?
All national institutions, IITs, my lord.
No.
I can place it on record. IITs, IIMs, all institutions of national
Please
importance.
place that on record.
I undertake to do that.
Place it on record.
Because they do not provide for any reservation.
No, we are not, there's no question of reservation because that's barred under Article 15 and that's.
Maybe the atmosphere they have given to the institution, IIM, for example, anybody would go. But I do not know, but
Just get us the.
we would get it. I'll need 2 or 3 days, but we
We may
would.
not be able to get it for a lot of institutes, but maybe institutes of substantial.
Prime institutes, definitely will be. Page 115, I have given of 2B. Please come, just institutions of national importance. Your lordships may perhaps not require the figures. 2B, but I undertake to give it. 2B, page 115,
volume 2B,
volume 2B,
page 115.
5. They all have a lot people, students from all spectrums of life. Please see, Aligarh, Banaras, we leave. University of Delhi. Then Atal Bihari Vajpayee, Indian Institute of Information Technology and Management, Indian Institute of Information Technology. Then, please come to the next page. All IITs.
How many institutes have you listed under this?
In this list, the total number is 165.
Okay, for these institutes, can you give us the breakup?
I will. Regarding which, it consists of the cost.
May not be available. In fact, it may not be available also, but if it's available, please give us.
Religion-wise may perhaps not be available, but AIMS,
But if it's available, just give it.
but otherwise, AIMS, IIMs, IITs, your lordships can take judicial note. It is for all spectrums. Now, please see, my lord, what triggered this petition. 3E, volume 3E, page 34, my lords. This was under challenge before the High Court.
The solicitor, could you come to 33?
33. Same 3E.
Same volume, 33. It refers to a letter received from the Assistant Director dated 3rd December 2004.
They have read, my lord, yes. That is based on 81. He writes that now you are a minority institution, which they have read, my lord. That is, my lord, at page. What that
What is
Sanjay
the page
saying?
number of this 312?
I'll just give the page number, my lords. Lordships may give me a minute.
This letter is the first time they recognize the it is.
17 is page 17.
Page of this volume. 17, my lord, of this volume.
Page 36. Which is a letter. Page 36.
Page 17?
3B, 3E, I'm sorry, 3E for
3E, yes.
elephant.
Because page 39 may also be read in 3E. Very important.
Correct, you read it. I will again read it. There is no difficulty.
I did not read.
It was,
I read.
Mr. Dhawan read. Anyway, I'll read it again. Now, please come to 34 first. Because my learned friend, my lord, said that ultimately after doing all this, what we need, what we are asking for, some reservation. That was the argument, my lord. I am just showing what is that some reservation in an institute where without reservation there is 70 to 80% persons from one particular community. Please see, my lord, page 34, your lordship gets, my lord. Can I read? My lord?
Yes.
34, at the foot of the page, my lord. After detailed deliberation, my lords get, my lord Justice,
Yes.
Justice Particular. After detailed deliberation, the council approved the recommendation of the academic council made at its special meeting held on 15 January 2005 regarding reservation of seats for admissions to MD, MS, PG diploma courses in the Faculty of Medicine with minor modifications as mentioned below. 25% students may be admitted from amongst the internal candidates on the basis of All India test, meaning thereby BSc to MSc, MBBS to MD, etc. 50% of seats may be reserved for Muslims of India to be selected on the basis of All India entrance test. So 75% roughly, not for Muslims, because 70 to 80% as on date who are studying are Muslims. That's an admitted position. Mr. Farasat gave those figures. And I can also give those figures. That without reservation also, 70 to 80% are Muslims. So they would go from bachelor's to master's and 50% straight flat reservation for Muslims and open only for 25%. And this is ranking, my lord, one of the finest universities in the country. I have no dispute about it. Apart from, my lord, it being an institution of national importance, I am not taking your lordship, my lord, through that. But please, my lord, note here, only for my satisfaction, my lord, I have pointed out the debate of the Constituent Assembly when this was declared to be an institution of national importance. I am not, my lord, reading it, but there are good reasons, my lord, they have given. And page 9, para 16 to 21, para 21.
Page 9, paragraph 16 to 22.
Yes,
That's in your written submissions.
my written submissions. But I have quoted, my lord.
Volume?
2B.
Just, Mr. Solicitor, just get the data, because data may be available online, but may not be authentic and accurate. If the government has any data, please give that.
But I will. But possibly, this is my impression, I'm not making a statement. Possibly, now, when I fill up the form for admission, the religion is not
No, in minority institutions, probably it will be there.
minority, yes.
But
Yeah,
the government,
it has to be.
in the other institutes, probably it's not required and may not be in fact mandated, should not be in fact.
Should not be. Like IIT, IIM,
But
other.
otherwise, the government must be having some data, some figures.
If it is, my lord,
Otherwise,
I'll
figures are available
hopefully
online,
place it on record.
figures are available on the internet, but they may not be.
Accurate, correct, my lord, then. So, my lord, last line, my lord, I'm not reading it, but this Article 15, sub-article 5, when was inserted, was put to challenge, and the challenge is negative. My lord, that is the judgment in Pramati, my lord, 2014, volume 8, SCC, page 1. My lord, relevant para is 31 to 34, 31 to 34.
Just repeat the citation.
2014, volume 8, SCC, page 1, relevant para 31 to 34.
That rejected the constitutional challenge.
Constitutional challenge to sub-article 5 of both Article 15 and Article 16. My lord, my submissions are over, my lord. I'm immensely grateful, my lord, very patiently.
Thank you.
For a very patient hearing, my lord. Obliged to.
Thank you, Mr. Sachs.
It's okay.
Before Mr. Trivedi begins, may I have your lordship's kind permission to make a mention about this matter?
Sorry?
May I have your lordship's kind permission to make a mention, my lord? Lord,
Who are you appearing for, Mr. Yatendra Singh?
Lord, my briefing counsel in this particular matter has become a judge of the High Court. And then this last month, my lord, due to my health reason, I was not coming. Last week when I came here, the case is here. I want your lordship's kind permission to submit my written submissions. And 10 minutes of your lordship's valuable time, at whatever time your lordship thinks proper, give me just 10 minutes or maybe 7 or 8 minutes.
All right, let's complete the hearing, then we see how much time we have left.
Should I upload my written submission, my lord?
Just wait presently, we'll see. Have you filed an intervention? Have you filed?
Lord, my briefing counsel with whom I was appearing, there were parties in the case. He is elevated. I do not have any connection with the AOR, and probably this is the reason it has happened.
All right, let's wait for a little while, and then we can see what ground is covered, and then if there's something else, we'll give you 5 minutes at the end to make your point.
I'll finish within 5 minutes.
Certainly.
Obliged, lords.
What you can do is that you can circulate your written submissions to the other side, so they also know what your point is, and then circulate it to the court master in the electronic form. So we'll add it to our submissions. You can circulate it to the nodal council. The nodal council will then put it together. That's better. Yeah, yes, Mr. Dwivedi.
The first submission which I wish to address is that to be a Muslim is one thing, and to be a minority is another thing.
To be a Muslim is one thing, but to be a
Minority.
what do you mean?
For
to-
example, if we are in Jammu and Kashmir, majorities of Muslims are not a minority. It's in that sense, the question therefore would be either we proceed on the basis of the assumption which was made in Aziz Basha that the Muslims in 1920 were a minority and decide whether they're entitled to the benefit of Article 30, or we consider the question actually on facts, not whether they were a minority in 1920, which requires, first of all, determination of the most vital question, which somehow has avoided the attention of this court in most matters, whether they were Christian colleges or whether they were Muslim colleges established before independence. This court has proceeded on an assumption that they were a minority.
So how do we understand this concept minority? Do we decide this today in a bench of 7 judges when your lordships are sitting? Or we again, my lord, like TMA Pai say that these questions are left over, my lord, to be decided later. This question was squarely there, my lord, in question 1 and question 3A. But all that TMA Pai decided was that minority will be decided state-wise. But what is this minority? Is it a numerical question? Does it have a qualitative content? Does it not require that the people who are now claiming to be a minority understood themselves to be a minority at that time? Only then, Lord, this can be proceeded. So either we avoid it, we say that today in India, the Muslims are a minority, and therefore we will, from that we jump to the conclusion that in 1920 also they were a minority.
But nobody has questioned that, Mr. Dwivedi.
No, I am raising this question, Lord, and that is referred. That is referred. The 2 referring orders, if your lordship will look, Lord, this is the question which has not been addressed. Volume 3A.
The question which has really been addressed before us is whether they are established and administered by
A minority.
Right.
Therefore, Lord, were you a
The fact
minority?
that they were, that Muslims
So were you a minority?
The fact that they are a minority today in UP, and that the fact that they were a minority at that relevant point of time, because whether they were a minority or not has to be decided on today's standards.
No, no, no.
There's no
no.
different
I'm
standard in
sorry, but
1920 as compared to.
that's precisely the point.
Just getting, it's just a question. That's the thought.
Before the constitution, adoption of the constitution, we didn't have any concept of minority and majority. Certain rights have been given under the constitution on which there is no issue in terms of the different articles from 25 to 30. Therefore, the determination whether you are a minority or not has to be done on the basis of a set time period, not in the past. When we refer to establishment prior to the constitution, we'll have to go back
In the point of time when the institute was established,
Yes.
but not with reference to whether that community was a majority or a minority community at that time, but with reference to who had established.
No, but great is-
Who is the minority or majority will be decided on the date when the constitution was adopted. Possibly, what argument you are raising in case there is a demographic change, what will be the effect is a separate issue.
No, well, your lordships have categorically held in number of cases that fundamental rights are not retrospective. So therefore, only question is whether are you entitled to avail the benefit of Article 30 today? In order to do that,
Will it be
in a- in order-
retrospective? Sorry, interjecting, sorry. Will it be retrospective or retroactive then?
whether it is retrospective or retroactive only means, Lord, that the law today takes notice of the facts earlier, that is retroactivity. When the law is retroactive, it doesn't mean it operates from that day, but it takes note of the facts as they existed earlier. So we are on the question of facts, an assessment of whether this community was a minority when it established. If it was not a minority, and if it did not consider itself to be a minority, then, for example, let's take the Christians, Lords. The Christians were the rulers of the time.
The British government, which was ruling this country, was a Christian government. And the missionaries were brought in this country with a particular purpose, as an arm of imperial rule. And being that, Lord, under the charters of 1813, 1833, the English Education Act 1945, the
Wood's Dispatch of 1954, and the Hunter Commission and all these commissions were really meant to provide an opportunity to the missionaries to establish the college, to create people who were not fair like them, but they thought and whose tastes were like them. That was the objective. That is the great minute of Macaulay. Now, institutions which are established by missionaries to evangelize, to convert, to make Indians like British, and they were given grant of land which was occupied by them. Now, are we going, Lord, is this constitutional intent that Article 30 is to be given a benefit to these kind of institutions which were meant for a colonization purpose, for imperial rule purpose?
But that's not the character of AMU. Why should we decide that question?
Now, AMU question, therefore, we need to decide the question with, I'm coming to the Muslim minority.
What was the political unit within which AMU was then established? There was no state of Uttar
Whether
Pradesh
you-
at that time.
Whether you take it as a state unit or national unit, for my submission, may not be very pertinent for us. But we have to take British India because Indian states were outside.
Or we take the Northwest Province or subsequently the United Province as it was called. What was the status and position of the Muslims then? Could it be said in 1920 that they were a minority? The rule was of the Christian British rule, who were less than the Muslims. Neither the Hindus nor the Muslims, we were both subjects. We were not even citizens of Britain. There was no concept of citizenship, even that this court has said in Patro's case. So therefore, there is minority rule in India. That's the unfortunate part, not only in India, but in so many other parts of the globe, where the British imperialism was ruling. The position was that a handful of people were ruling over India for the last several hundred years.
So are we to say, my Lord, that the Mughals were in minority, the British imperialists were in minority? This will be something very, very strange, my Lord, that after being a republic, we are trying to bestow a characteristic, a status of minority on those who were not a minority. The Muslims were more than the rulers. The Christians who were ruling through the Governor General and the HMG, His Majesty's government, they were smaller in number than the Muslims.
Therefore, I request your lordships to first of all, instead of again avoiding to go into this question, please decide this question. It's too long, my lord, for 75 years and more, my lord, we have been evading this question. And we just assume and we stamp them as a minority institution and confer the benefit of Article 30 to them. According to me, there are three aspects, my lord, of
This minority. And this is a question, Lord, which has been referred to your lordships.
the first referring order says, Lord, decide the essential conditions or ingredients of the minority institution may be decided once for all. That is volume 3A, page 209. In my additional written note, Lord, which is 2J, volume 2J, in first paragraph, I have extracted this portion. Volume 2J. It is all right for the petitioners to proceed on the assumption, my lord, as in Aziz Basha, but what is referred to your lordship is decide essential conditions or ingredients of the minority institution, which may be decided once for all. And the second referring order refers to TMA Pi, and that's one of the reasons for referring the entire matter to your lordships. That is question 3A, which is framed in that case, TMA Pi. What are the indicia for treating an educational institution as minority educational institution? Would an institution be regarded as minority educational institution because it was established by persons belonging to a religious or linguistic minority, or it's being administered by a person belonging to a religious or linguistic minority? So first of all, we have to decide this question. And I am placing three characteristics, which are absolutely essential. Why was Article 30 needed as a safeguard or protection? Because of the fear of domination by majority. So it's a protective, it's a safeguard. Number two, Article 30 will walk hand in hand with Article 29(1). It can walk separately also. It's up to the religious minority concerned to decide how far they wish to go. These are not simple provisions of reservation. The object is to enable them to maintain their character as a religious minority. And in that respect, Shahjahan was right. To reduce it to reservation is to completely kill this Article 30 and equate it with 16 and 14 and 15. So being a protective safeguard, what follows is there is an idea of domination inbuilt in this. The fear of the minority, that is character, that is culture, that is language, that is script, may be overridden and demolished by the majority. So therefore, a minority
is that which is less in number than the ruling majority.
How will you apply this test?
this test will apply. Who was ruling at that point of time? Were you less than them or more than them?
That means ascertaining.
Ascertaining the numerical test. I call this a numerical test. If the Christians are ruling, you aggregate all the Christians, aggregate all the Muslims of various sects, and decide whether they are less in number or not. That's a numerical test in my humble submission. The second test is a test of non-dominance. So if that particular community, though being less in numerical, in numbers, if it is a ruling power, then it cannot be a minority. Less in number and non-dominant. Because that's the correct idea underlying Article 30. If you are ruling, then you don't need a safeguard. You don't need to protect yourself. That's the qualitative test. And the third is that the community which is claiming that status should be considering itself to be a minority. The group which is founding the institution should be considering itself to be a minority.
Repeat the third test, Mr. Trivedi.
The third test is that the community which is claiming to have established the institution should be considering itself to be a minority.
The founders should consider themselves to be a minority.
Minority, yes. If they reject that claim and seek some other status, without these three factors being considered as on 1920, we will be looking at history in a blinkered way, in a partial way.
On that aspect, you see, the third aspect, leaving the third aspect slightly aside, when we refer to a statute being retroactive, we'll have to and also take into account what is the object and purpose of the Article 30, which you have yourself articulated. Go back in point of time to find out who are the person who has established that institution. But the question whether they were in minority or not at that time may not be relevant. What will be relevant is whether on the date when the issue is being examined, whether they are minority or not.
No, the issue is they have a right to establish. Today, no dispute.
What you are saying is, we'll have to go back in point of time and examine whether when it was established, it could be treated as a minority institution, because there was no
We
concept
are
of.
going back, we are considering who founded in 1872 the primary school, who founded it, the secondary school, who founded MAO,
What is the
who
parameter?
contributed, we are going back.
We are going back.
But we want to stop and we don't want to consider the character of this group at that point of time, the character which this group was claiming for itself.
But Mr. Dwivedi, apply your three tests. Your first test is minority has to be less in number than the ruling majority.
Yes.
Now, going by that test, the ruling majority, as you rightly said, was the imperial government. Therefore, those people who founded were certainly less in numbers.
Those who were ruling were a ruling minority.
There was no minority.
Right, but
And Muslims were more than the Christians at that time.
that can never be the test, Mr.
So, look, therefore, that's the whole point. We want to consider everything in history, but not that part of the history, Lord, which is absolutely relevant, Lord, to this.
Because we were ruled by colonial power, which was hopelessly, of course, it was a minority, but that's the whole point. That was the whole that was the whole genesis of the freedom movement. But to therefore say that any claim for minority status has to be rejected because those who were ruling were in any case a minuscule minority.
The reason is this.
Can we now deny minority status because of the fact that, well, the rulers were in any case in a minority?
That the whole problem is arising because the constitution has given a right to the present minorities, the Muslims, the Christians, and whoever else is, to establish and administer. This is a right which is given by the constitution and operates ex post facto. But by judgment, Lord, we have tried to accommodate and extend it to a scenario which existed prior to the constitution.
So therefore, to see whether you are entitled to a constitutional right, you look at the status or position as on the birth of the constitution.
And even afterwards.
Right, and thereafter. Now, according to you, you have to go all the way back at the point of the birth of the institution.
So either we go or we don't go. If we don't have
but if you do, the test cannot be the numerical majority in relation to the rulers at that time.
Has to be, Manoj, otherwise if you are not a minority, otherwise what are we doing? What are we doing? We are taking note of, we don't want to take note of the act. Then don't look into the history at all. Look at the act. Act says it has been established by the Governor General in Council at the end of the matter.
So prior independence, then according to you, there will be no minority at all.
There was no minority institution at that time. We were all subjects. The Hindus and Muslims were at par. I was as subject as they were.
Is the sequitur that any institution established prior to independence would not be a minority institution?
Yes, that's my humble submission, and this court has committed an error in my humble submission with deference by not examining this aspect, by simply assuming in every case that. So what is the result?
When the Constitution says in Article 30, all minorities, either linguistic or religious.
So established, today nobody says.
But when it says all minorities, it certainly looks at the position, the sociological position and the historical position prior to the birth of the Constitution.
It cannot be, Milords. All minorities
are not created for the first time post 1950.
The question which I am posing for your Lordship's kind consideration is the Constitution attempting to
how did they become minority?
Force us to imagine that India was actually a republic in 1920. What are we trying to do by taking it backwards?
We are caught in a
Of course, it's all. How many judges? 9?
6 or 7. Just tell you.
Is the consequence of this assumption is not, we are actually trying to take the constitution and applying it retrospectively. We may call it retroactive, or we are applying the principles of it backwards. No, we are actually giving.
Not like that. We also have to understand the historical perspective of the Constitution. Why did the Constitution introduce certain safeguards? It was a safeguard intended to
hold out an assurance to communities which were otherwise joining the mainstream of the Constitution that you will be protected. One article of that protection was your right to establish and administer educational institutions of your choice.
No problem, my lord. After 1950, nobody is contesting. I am also not contesting that all these people who are now actually a minority, they are entitled to establish, and they are establishing. Nobody is preventing them from doing so. The problem is arising only when we are taking these principles back, my lords, and backwards, and not for a few years, but several decades. And then saying, because most of the colleges established by Christian missionaries are between 1850 and 1900. So we take it back 100 years and say that even though you established this institution as a ruler, as governing arm.
There can be a number of arguments, counter arguments, etc. Why can't we have more institutions being established of equal status and character or equal excellence? There can be a number of arguments on either way. That will not. Real issue is did the Constitution in Article 30 say? The Constitution was certainly aware that there are minorities in India. There is some safeguard to be, in spite of the partition of India being on religious line, they said we will adopt and give certain safeguard to the minorities. That's the commitment of the Constitution. And on interpreting that, if we accept your argument is, all institutions which had come up prior to 1950 will no longer, there is no need to examine whether they are minority institution or not.
That is correct. That's what I am submitting with, and this is something which your lordships have not debated and considered and decided.
Well, as in Kerala Education Bill, I'll just read, there is no reason why the benefit of Article 30, Sub-Article 1 should be limited only to educational institutions established after the commencement of the Constitution. And language employed in Article 30, Sub-Article 1 is wide enough to cover both pre-Constitution and post-Constitution institutions. 7 judges of this court. I have to revert it to 9.
No, it doesn't matter. 7, 9, and 11. Well, that's for a lordships to decide. But the question, what is Henry Kerala saying? Kerala is not saying, my lord, that they were considering a presidential reference. So supposing, my lords, before the Constitution, the Parsis have established. They are numerically small. They were a minority. They were less than the Christian ruling powers. They will be entitled.
It's not saying don't examine whether you were a minority then or not. That is the problem, that there are not really Kerala, other cases also assume, in Patro it's assumed that they are in minority. It would be a very amazing conclusion that Christians who were ruling at that point of time. Today, yes, they are minority. But at that point of time, you ruled over us.
You were evangelizing. Your mission was that. And we are ready to give a stamp of minority and the benefit of Article 30 to them.
Those missionaries who came here and to do evangelization, to act as an arm of colonial rule, with great respect, to confer upon them the status of minority, will be completely, that's not the, no provision in the Constitution, gives has any intent of being retroactive in this sense. They were the arrowheads of Western cultural imperialism in India. And we are saying that you are minority, you get the benefit of Article 30. So we forget, we take note only of the fact that Mr. Syed Ahmad Khan was inspired. He wanted to attract Muslim youth to Western education. So he set up a primary school. And he set up the primary school in 1972, 1872, even while being in the employment of the East India Company and thereafter under the British government.
He retired from the British government service in 1878.
As an employee of the British government, he establishes a primary school, then secondary school, and then MAO, gets a grant plot from the British government. Then he becomes an Imperial Council member for 8 years. Then he becomes a member of the Council of the Northwest Province. So what he's acting as an arm of the government. British government had certain specific intent with regard to Muslims and Hindus. So again, Lord, we have to forget all those things. He was an arm. Whilst being a government servant, he is establishing this. With the aid of government grant, with the aid of government money, with the aid of money which is coming from the Nawabs who are of the Indian state, which is also a government. There is the private community sprinkling maybe here and a small amount of collection. Everything was because of that. Viceroy Lytton will not come all over to inaugurate MAO merely because he was an employee of the government, sub-judge at that time. Therefore, he comes there with their own objectives, imperialist objectives. These schools and colleges, the group headed by Mr. Syed Ahmad Khan by itself neither had the right to establish an institution, nor they had the power to establish the institution, nor they had the capacity to establish it.
Everything flowed in from
the Governor General's government and from the provincial government. The 30 lakhs money came from Nizam. He is a ruler of the Indian state. But we can start looking at his face and his belief and then say he is a Muslim. But he is a ruler, monarch. Maharaja Patiala, he was a monarch. Maharaja Vijayanagaram, he was a monarch. They are all made patrons, lords, in the AMU Act. Where from the fund is coming? Not from the community, but from those who are governing the British government itself and the loyal princes. Now we can say we will not look at the loyal princes, but the Chamber of Commerce Princes, which was constituted in 1923. We can also overlook that the princes were not the breakers of storm which comes in India. Freedom struggle, every force which was against the freedom struggle, to all of them, we are very grateful and we confer the status of minority. It's not established by them. They don't have the capacity. They could not run it. Yes, they wanted a university to request and to negotiate non-essential terms and to be members of court. If that is sufficient to establish, I submit it is neither founding nor establishing. what was the status, Mullahs, which Sayyid Ahmad Khan was seeking, Mullahs? I have annexed his own letter, Mullahs. Kindly see my written submission notes at volume 2H. Page 18. They considered themselves to be a separate nation, not a minority. He is the founding father of this. Kindly come to page 18, the footnote where the letters was, which is the speeches which he gave in 87, 88. Worships have it. We ought to consider carefully our own circumstances and the circumstances of government. If the government entertains unfavorable sentiments towards our community, then I say with utmost force that these sentiments are entirely wrong. At the same time, if we are just, we must admit that such sentiments would be by no means unnatural. I repeat it. If government entertains these bad intentions,
it is a sign of incompetence and folly. But I say this, we ought to consider whether government can entertain such thoughts or not. Has she any excuse for such suspicions or not? I reply that she certainly has. Think for a moment who you are. What is this nation of ours? We are those who ruled India for 600 or 700 years. From our hands in the country was taken by government into its own. Is it not natural then for the government to entertain such thoughts? Is government so foolish as to suppose that in 70 years we have forgotten all our grandeur and our empire? Although, should government entertain such notions, she is certainly wrong. Yet we must remember, she has ample excuse. We do live on fish, nor we are afraid of using a knife and fork lest we should cut our fingers. Our nation is of the blood of those who made not only Arabia but Asia and Europe to tremble. It is our nation which conquered with its sword the whole of India, although its people were all of one religion. I say again that if government entertains suspicions of us, it is wrong, but do her the justice and admit that there is reasonable ground for such suspicion. Can a wise ruler forget what the state of things was so short a time ago? He can never forget it. If then Mohammedans also join the monstrous and unreasonable schemes which are impossible of fulfillment and which are disastrous for the country and for our nation, what will be the result? If the government be wise and Lord Dufferin be a capable viceroy, then he will realize that a Mohammedan agitation is not the same as a Bengali agitation, and he will be bound to apply an adequate remedy. If I were viceroy and my nation took part in this affair, I would first of all drop down on them. In time, Lord Ripon, I happened to be a member of the council. Lord Ripon had a very good heart and kind disposition and a very qualification for a governor. But unfortunately, his hand was weak. His ideas were radical. At that time, the local board and municipality bills were brought forward, and the intention of them was that everybody should be appointed by election. Gentlemen, I'm not a conservative, I'm a liberal. But to forget the prosperity of one's nation is not a sign of wisdom. The only person who was opposed to the system of election was myself. If I'm not bragging too much, I may, I think, say that it was on account of my speech that Lord Ripon changed his opinion and made 1/3 of the members appointed and 2/3 elected. Now just consider the result of election. In no town are Hindus and Mohammedans equal. Can the Mohammedans suppress the Hindus and become the masters of our self-government? In Calcutta, an old bearded Mohammedan of noble family met me and said that a terrible one of whom a calamity has befallen them. In his town, there were 18 elected members, not one of whom was a Mohammedan, all were Hindus. Now he wanted government to appoint some Mohammedan and he hoped government would appoint himself. This is the state of things in all cities. In Aligarh also, there are not special rule. It would be impossible for any Mohammedan except my friend so-and-so to be elected. And at last, he too would have to rely on being appointed by government. Then how can we walk along a road for which neither we nor the country is prepared? Kindly overturn Kindly turn over leaf, Lords, at the bottom. This is second speech extract. The letters are annexed. After this long preface, I wish to explain what method my nation, rather whole country of this country, ought to pursue in political matters. I will treat in regular sequence of the political questions of India so that you may have full opportunity of giving your attention to them. The first of all is this: in whose hand shall the administration and the empire of India rest? Now suppose that all English and the whole English army were to leave India, taking with them all their cannon and their splendid weapons and everything. Then who would be rulers of India? It is possible that under these circumstances, two nations, the Mohammedans and the Hindus, could sit on the same throne and remain equal in power. Most certainly not. It is necessary that one of them should conquer the other and thrust it down. To hope that both could remain equal is to desire the impossible and the inconceivable. At the same time, you must remember that although the number of Mohammedan is less than that of Hindus, and although they contain a far fewer people who have received a high English education, yet they must not be thought insignificant or weak. Probably they would be by themselves enough to maintain their own position. But suppose they were not, then our Mussalman brothers, the Pathans, and promote as a swarm of locusts from the mountain valleys and make rivers of blood to flow from their frontier in the north to the extreme end of Bengal. This thing, who after the departure of English would be conquerors, would rest on the will of God. But until one nation had conquered the other and made it obedient, peace could not reign in the land. This conclusion is based on proof so absolute that no one can deny it. So therefore, my Lord, this is what they thought of themselves. The group, I'm limiting myself to the group which is said to be pioneering, my Lord, the establishment of institution. I'm not talking about the entirety of the Muslims. They were nationalists also. There were people who did not believe in the two-nation theory also. But here is the moving spirit who never thought that he is a minority.
His spirit was that we are a nation. His spirit was that we have to be loyal to the British. And even the British thought like that. They also said India is a multinational. So this concept of minority was not there. Should we then, my Lord, ignore all these important aspects of history? At no point of time before his death in 1898, he changed his views. And it is this inspiration which led to the grant of separate electorates in 1906 and the division of Bengal in 1905, which led to the freedom struggle, my Lords. And why did this movement for the University of BHU and this start, my Lord, in 1915 and 1920? Both cases, the request was made in 1911. That's the record on this, Mr. Shafi's speech itself. The request was made in 1911 when the Prince of Wales was visiting India, when India, my Lord, the capital was being shifted to Delhi. And Bengal was reunited. That's why in the speech, my Lord, all this is coming. The rise of and the renaissance of Bengal was behind this. So in 1911 it started. They made a request. There were negotiations begun. And at that time, BHU accepted the terms and conditions, the format, the scheme of administration, and therefore BHU Act was made in 1915. Now, they were resisting, not accepting. Ultimately, they fell in line. All that has been shown to your Lordship. The Governor General says, you accept the BHU pattern. That's the command. was no choice to them. Kindly bear in mind one thing, that the Governor General was the supreme power. He could do whatever it wanted. It is one thing to say that the university is established by the Muslims. It is another thing to say that the university was established by the Governor General in Council for the Muslims. There is a distinction between by and for. Even today, my lord, the government, the parliament can pass an act saying that for tribals we are establishing a university. The tribals will be member of the court. The fact that it is meant for tribals will not mean, my lord, that it has been established by tribals. The tribals may go from Jharkhand, my lord, and Chhattisgarh and the northeast, and they may request the government of India to give them a university. They are not getting enough educated students from their midst. And acceding to the request, the parliament passes an act saying that
This will be a tribal university. So it's not established by tribals. Nothing prevents the Governor General Council to form a university, to establish a university, to found a university for a particular denomination, community, tribals, scheduled caste, whomsoever they wanted. They had absolute power.
what they do in this case, from MAO college to the university, is a change of status and level of education. I have, Lords, in my written submission, Your Lordship, will, because of time, Lords, I will not be reading through all the paragraphs. I have brought out, Lord, from the basis of Wood's dispatch of 1954 and the Hunter Commission, because the Hunter Commission was not concerned with university. It is the Wood's dispatch, Lord, which is the foundation. Wood's dispatch 1954,
which is on record, placed by the government, which is the starting point of universities in India.
First, Lord, in 1857, 3 universities: Calcutta, Bombay, Madras. All 3 established by Act, initially, Lord, as an examining university, then in 1860, Lord, to award degrees and teaching also. In 1882 comes the Lahore University in Punjab. And in 1887, Allahabad University. In 1904, after a commission's report in 1902, in 1904, the Indian Universities Act was enacted, and all its provisions were read into the act of the 5 universities which were existing. It says so in section 2 that all the provisions of this should be read into that.
It provided a particular structure of administration.
And the format was based on the London University. What is the importance of this, Lords? Importance is that whilst the British government allowed private persons to establish schools and colleges, it kept the power to establish a university to itself. There is no British policy shown to your lordships, and based on these policies which we have placed on record, there is no British policy which enabled private persons to establish university. That is the reason why the Hindus and Muslims had to make a request to the Governor General in Council, for they alone had the power. In fact, in the Lahore University, I have mentioned, there was one gentleman, he was a Christian, and he led a movement, and he made a request to the Governor General in Council to establish the Lahore University. So the fact that somebody is behind the move, behind the request, or contributing some little thing,
some existing property, that is not founding, that is not establishment. In my submission, founding and establishment are synonymous. It can't be founding that I have gone to the Governor General in Council. So you say you have not established, but you have found.
Mr. Sirvai is not right. Great respects to the eminent jurist, and many a times your lordships have accepted what his criticism, many a times your lordships have not. In the context of Article 30, founding and establishment was bringing into existence is one and the same thing. Founding is not making request. Founding is not going up to the Governor General and meeting some officials and negotiating something non-essential. Supposing I go to the Governor General and say, I have some little property of 5 acres, I can't establish university. You please bring in more land, etc. You have enough funds, so you can establish it. Give me some role in this. Is that founding? Is that establishment? So therefore, let us not quibble and semantics. Contextually, it can mean nothing else. Founding is nothing short of bringing the infrastructure, bringing the funds, bringing the faculties, and constituting the framework, the most important, constituting the scheme and framework of the university's functioning. Today, minority institutions are being established. It is the societies and the companies which are formed which present their own scheme of administration. They appoint the chancellors, the visitors. The scheme is formed by them.
But Mr. Dwivedi, just as we are concluding, you may reflect on it. Your position, therefore, is at variance with what the Solicitor General argued. Because the Solicitor General argued that there was no prohibition on any private individual establishing a university in British times. If you wanted to do it, you would not have recognition for your degrees. Your position is that, look, there was no
question of any private person establishing a university. It had to be done by or under an
just a little qualification.
Charter of the imperial power.
Yes, just a little qualification that this is in the context of universities whose qualifications and degrees are recognized. Private universities, you can go and establish, your degrees will not be recognized. I am limiting my submission to universities whose degrees are recognized, who are imparting Western education, Western science, liberal arts. If you are having a Sanskrit university of your own private, that's a different thing. That we had from long back, Nalanda universities and all that. The university is not a concept which is emerging for the first time, but that's what they wanted. Solicitor also said the same thing. He was referring to Vishwa Bharati and other Kashi Vidyapith and Jamia and so on. So that's there you don't require the Governor General. And there was no law which said that you can't use the word university like today. But if you wanted to have a university whose degrees are recognized,
And only Governor General could do it. There was no policy. University as a subject was expressly excluded from the Hunter Commission. Kindly advert to the recommendations of the Hunter Commission, my lords, it was excluded. So they went to the Governor General because they had no adequate land, didn't have adequate funds, no capacity, and they knew that it can't be established unless Governor General creates it.
Come back after lunch. 40 minutes. Yes, Mr. Dev.
Before I proceed, Lord, I'll request your lordships to have volume 2J. Page 4. And kindly note these, Lord, the definitions of minority, which is from the United Nations General Assembly. Para 10, 11, 12, 13. The first definition is designed by Francesco Capatorti, Italian lawyer who was a representative of the Italy in United Nations General Assembly, which was slightly modified then by the Canadian
Really,
judge.
which page?
Four.
Yep, volume 2J, that's the additional written submission. Volume 2J, page 4. And in para 12, those definitions find resonance in United Nations Commission for Religious and Linguistic Minorities. I'm sorry, it's the Indian. It's the Indian National Commission for Religious and Linguistic Minorities. And then from Britannica. This note I had already submitted that is actually flowing from the objective of Article 30, the idea of dominance. Otherwise, Article 30 is not required. Also note at page 9, para 24.
If we go by the question of dominance,
Yes.
may have some repercussions, even may have a lot of repercussions otherwise. But otherwise.
It matters not what repercussion it has. The question is to define. This court has been avoiding definition. So let's define it appropriately, then everything, in every case, it can be applied. Otherwise,
Your approach, Mr. Dwivedi, would be that the conferment or denial of minority status would depend upon the position of the founder in relation to the dominant ruling group. Not the position of that minority in relation to the ruling group, but that the founder, for instance, in this case, it may be well conceivable that the Muslims were in fact in a minority, I mean, in the constitutional sense, I'm just using it as a tag. But you are saying that because Sir Syed Ahmad Khan, he became a sub-judge, he was employed in the British East
that's
India
a separate
Company.
argument.
Therefore,
That's a-
his
no, no, no.
relationship with the government was not, he didn't consider himself to be a
No,
minority.
that's a separate argument. That's the third limb.
So it has to be the position of that group. It's a group right. It can't be in relation to the position of the individual, the rest or.
I'm sorry, Manoj. I said there are three aspects of minority. One was numerical test. The second was the dominance test. The third is, did you consider yourself to it? So that part of the submission pertains to the third limb.
But
not
the dominance
second.
also, dominance would pertain, even if applying your standard, to the entirety of the community. It can't be the dominance in relation to the founder. That because the founder was kowtowing to the then powers that be, either in pre or post independence India, therefore that
With utmost deference, Lord, minority is a political concept. It relates to somebody, some group which is in majority. It's a political relationship which is now, Lord, enshrined in the Constitution in the form of Article 30 for futuristic purposes.
For instance, say a political party in a state may regard a particular minority A. I'm not taking any particular name of any minority group. A political party in power in a state may regard that minority as a very valid constituent, a very important constituent of its vote bloc. Does that mean that therefore, though numerically it is in a minority, or it performs or it fulfills all the indicia of a minority, because it is regarded as a very important ingredient of the ruling bloc, therefore it will be denied minority status under Article 30?
I'm not saying this in
because this will become subjective then.
No. I'm not saying in the context of the government which of the day. I'm talking in terms of the community which is ruling. We are talking of 1920 when a particular community was ruling to the Governor General. Take the community as a whole. Neither the Muslims nor the Hindus were part of that government. We were subjects alike. And we were equal in the sufferings.
So therefore, both the Hindus and the Muslims would fulfill the indicia of minority status?
No, there's no question of minority. The relationship was of the imperial ruler and the subject. We are all subjects. We are all treated alike. All subjected in the same manner. So there's no question, as the Solicitor General also said, that there's no concept of minority then. We are trying to foist something, my lord, backwards, my lord, on a statute made by an imperial power which was not there. No, this is just a fiction which we are creating. How do we do it? What principle, my lords? How do we, my lord, extract the principles which this court has laid down over the course of years, my lord, up to TMA Pi, and then say that we will apply it to 1920 and then discern, my lord, whether this particular community was.
Because the claims of those who were established pre-independence are also subsumed within Article 30. It's not that because you have been established before independence that you are not entitled to 30.
That's the question which I'm raising for your lordship's consideration. Your lordship may not accept it, but then that has to be decided. Because your lordships, my lords, have at least 5 cases I have cited in.
But therefore is your contention that because prior to 1947 there was no concept of minority as we constitutionally recognize it today.
Yes.
Therefore it means that any institution which has been recognized, which has been established before 1947, or really before the advent of the Constitution on 26th of January 1950, no such institution would be entitled to claim minority status. It will boil down to that.
It will boil down to that, my lords. And the only exception which can be drawn, my lord, is a principle where some community was actually a minority, not in power, not in dominant position, like Parsis I gave an instance.
But there again, you say that the whole concept of minority was non-existent before.
Not in existence, but they were in numerically test, and the dependence non-dominance test, if applied, can probably, if we stretch Article 30, it was never meant to apply by any principle backwards, my lords. Just see, there are 5 cases in para 9, para 24, page 9 of the same submission.
Really, there may be some difficulty also because these definitions which you are reading of Western philosophers, etc., or UN, etc., are made in a slightly different context. When we are referring to Article 29 and 30, we are referring to certain things which are provided in the Constitution. What is in the Constitution itself? Because let's take the example, say the South Africa. The majority community, in fact, was not dominant.
There are numerous examples in
Now, it's also possible, therefore, if that is, if we go into all that, they can be also, they will be difficult. So when they're dealing with that, because here in India, we have given protection to various groups also. Ones which are marginalized, socially marginalized, we have been given protected. There are certain benefits also. Positive affirmation is also there.
That's all right. It doesn't impact that much.
So therefore,
Reservations
when we
are
are
not
referring
impacted.
to, when we are referring to 30, should we apply these definitions over here?
No, this definition is applicable independently. I had made a submission that the object of Article 30 is safeguard, protection.
No, that's a separate
From
argument.
that flows dominance. So this definition is apt. It is in sync with what I have submitted respectfully. That you are numerically less and non-dominant. The problem which your lordships are posing,
Then also dominance can keep on varying from time to time.
no, we are discussing, we are based on a
Let's assume-
constituent.
if we talk about political dominance, it can vary from time to time.
No, now we have a constitution, a republican constitution. Now Article 30 is in the constitution. So we have to proceed with the constitution as from 26 January 1950 onwards. How do you?
And dominance is also a function of socio-economic advancement. What if there's a community which does not have the benefit of education, as the Muslims were at that time? Community which was not highly advanced socially, economically, educationally. These tags of minority status.
From the angle of Western education, everybody was in minority. If this test is applied, nobody had, it all started in 1957. Universities, there were hardly 5. So we were all in the same position. It's not that the Hindus had Western education and the Muslims did not have.
So that may indicate that that constitution as framed did not mean to apply this test of dominance, because otherwise even Hindus were a minority in that.
Constitution has to, constitution you may not apply or apply. The point is, how do you apply any principle of Article 30 backwards 30 years ago and even 100 years ago? What are we doing? Well, in 1950, all missionary colleges, which is called college period for the missionaries, 1850 to 1900. So what are we doing, Lord? How far we are going back and taking these principles and judging, Lord, their status and giving them, Lord, the imprimatur of 30? Now, if the college is doing good, Lord, why will Parliament or any legislature, Lord, do something which takes away anything from that college? We have to trust the Parliament in that respect. Why extend 30 is the point.
All right, I'll ask you another question. What was that? What change took place on 26th of January 1950 that the Muslims, which according to you would not have minority status before 1950, suddenly acquire that minority status post 1950? What was the big change which took place?
The big change happened was that after whatever I had mentioned earlier, the separate electorates, weighted reservations, and this theory of separate nation. 1930, Allama Iqbal repeats in the Agra session of Muslim League. And from 35 to 47, entire Aligarh Muslim University, barring some exceptional individuals, was pioneering the Pakistan movement. Mr. Sibbal, perhaps, or Mr.
What happened on 26th of January 1950, which then elevated
by that time, India stood divided. And therefore, whoever...
But in relation to your threefold test, what is the change which takes place on 26th January 1950?
Change happened that those who were left behind, who had been beguiled into that theory of Pakistan, they were dependent upon a rule of the majority under the Constitution of India, which is likely to be most often of elements from Hindu community.
But presumably even...
So therefore, they needed,
But presumably even after post-independence, the Constitution assured an equal citizenship to everyone, whether you are a Hindu, Muslim, Jew, Christian, Zoroastrian.
Those who were resident,
we at a constitutional level, we assured an equal citizenship to everyone.
That's right.
right? In which case, how can anyone then claim that I have a minority status? Because this is
of
what the
30.
Constitution assures me.
Because of 30. But for 30, nobody could.
But that begs the question, because what does 30 recognize in terms of a
30
minority?
recognizes only this, not that you are a group of people who have subscribed to different religion, you have a different culture, you subscribe to a different script and language, Urdu, and therefore that needs protection.
But these are sociological features. These are sociological features. And those sociological features existed even prior to 1950.
It makes no difference whether it existed or did not exist. Before the British came, they were the rulers. It was a question of alliance and loyalty between two rulers of the past. So even if you go back, how many years will we go back? And say, even if 200 years back some school was set up, so minority rulers. The rulers are establishing for dominance over this country, for imperial rules, for exploiting this country, for destroying this country. And whatever constructions were done by them was for their advantage. Incidentally, it flowed to the others. They thought we will produce brown sahibs, but our intellect was such that we produced a renaissance in Bengal and it flowed all over the country. So that was our potential. But their objective was that. However, my lord, that's my respectful submission, which your lordship will examine, my lord, kindly, because we are, in no case we are defining, my lord, what is a minority. If you don't accept that definition or the definition which I am placing for consideration, there has to be some definition. If you apply see another angle, my lord. If you simply apply the numerical test, what happens? Let's take Kerala, my lords. Now, nobody is in majority. Let's assume, my lord, that there are Hindus, Muslims, and Christians, and each of them are at 33% or 35%, 30%. So how do you apply, my lord? Decide who is minority. Please define. These cases will come. And the reference requires decision. Nobody is in majority in there. It has to be some combination. Christians, Muslim, Hindu, Muslims or Hindu, Christians somewhere. I mean, this electoral politics will play out in its own way. But how will you decide? If you have simply a numerical test, then how do you decide Kerala? Nobody is in above 50%. Nobody is a majority. If we need a definition, now it's high time 2024, if we still don't decide the definition of minority, which the framers did not decide. So we need a definition. And we had the best test is objective test. Why was 30 needed? It's a safeguard and a protection. And the next question will be from whom? From the ruling majority. The fear, what was that fear? The whole argument for creating Pakistan was the fear of Hindu domination. We want a separate homeland. So the fear of Hindu domination, which was there, and it lingered. Kindly see what Syed Ahmad Khan says, we have not forgotten and we will not forget. They did not forget in 47 also. Gandhi ji pleaded with Jinnah, tell me maximum safeguards, whatever safeguard you want, I am ready to give. Agree to that. He said, we don't want safeguards because safeguards gave us a tag of minority. Whereas if you agree that we are a separate nation, then that idea of minority transmutes itself and we become co-sharers. That's why, Lord, in the cabinet mission, they were giving parity at the top, central level. They did not enter the Constituent Assembly, which started on 9th December 1946, because we had declared it will be a republic, democratic republic. Votes will be there. He said, vote doesn't help me. I have got 1 vote, Brother Gandhi has 3 votes. So we will never be protected. No safeguard works. So when Pakistan was finally created, then this question was that, all right, this is the safeguard. Article 30. So your fear of dominance of Hindus, this is meant to protect that. That's the objective, my lords, and I would request, my lord, that we can't look at history, my lord. We must look at our history wholesomely. It's not a deprecation, lords. I'm not against Muslims, and all the Muslims in India today have hardly anything to do, my lord, what happened before 1947. So we are all bound by fraternity, otherwise also. So no ill feeling at all. But we must look at the history, and the greater problem arises when we don't look at the history squarely on the face. We want to avoid looking at it, and we ultimately create something which creates more problems. After all, Justice Vanchu and all the learned judges in Aziz Basha are witnesses to what was happening, my lord, all through the two world wars. Justice Vanchu became an ISCS officer in 1926. So he is the witness of all that. Salmon Commission and everything, Lord, he knows what was. That's why is he assuming? He doesn't want to go into that question and decides on this established. Because if you go into this, whether Muslims are minority or not, at that time, there are complications. So why go into it? Decide on this basis. And this judgment has operated for a long time. The whole thing, this scenario has changed, to which I will advert to later on. For the time being, kindly just note, my lord, these judgments which I have mentioned in para 24 of page 9 of the same book, which say that fundamental rights cannot be applied retrospectively. If they cannot be applied retrospectively, then the principles underlying those fundamental rights cannot be applied retrospectively. We can't judge.
Which page were you saying, Mr.?
Para 24, page 9, this volume 2J.
Yes.
The learned solicitor has also, my lord, and is adverted to this. I've given the page and paragraphs. Some of the cases he has elaborated in his written submissions. I'm not reading these cases. It's well settled. But what follows from these judgments which say that fundamental rights cannot be applied? So we say now, fundamental rights will not apply retrospectively, but the spirit, the fundamental, the principles, etc., my lord, we will project it backwards and judge them from that angle today. But no constitutional principle permits that.
Mr. Dwivedi, merely because the circumstances relating to the transaction are partly drawn from the past does not necessarily render the fundamental rights retrospective.
I understand the distinction between...
For instance, suppose we are in 1951. Somebody has acquired a property in 1930. Property has come to a zamindar in 1930. Constitution is born. Property is expropriated. Can that person not assert a right under Article 19(1)(f)?
Yes. Why? The reason I'll tell you, Lordship. Because that property...
Because those certain antecedent elements are drawn from the past, the fundamental right arises on the birth of the Constitution.
That's right.
Likewise, Article 30 is basically a group right. That group right comes to be recognized on the birth of the Constitution.
Provided you had
what does that group right require us to decide? Who establishes and who administers? Now, one way of looking at it was who is establishing it now in 1950. But that would not be a correct reading. Who established this institution on the birth or the founding moment, as they were saying? Now, the founding moment, you therefore look at not for extrapolating the fundamental right back to 1920, not at all, but to look at the circumstances in which that institution was created in the first place.
No, but we are doing more.
We come to the conclusion that it was not created by a minority. It was created by an operation of law, by a statute. That's a separate issue. No, happened to so apply to a variety of rights. Somebody sets up an industry in 1925. Industry continues. Does that person not have a right under 19(1)(g) on the birth of the Constitution?
No.
You have a right.
So let's examine this, my lord. Supposing somebody sets up an industry before the Constitution. He had a right to do it. He had set up an institution. He had a property right. that property right by virtue of Article 395 read with 372, etc. continues. And therefore, the fundamental right he gets from the date. When we come to Article 30, the persons whom we are talking about did not have a right. There should be some right which is being protected and carried on in a different shape, in a higher pedestal. But if there was no right, and it was entirely on the mercy of the Governor General to do or not to give, then Lord, where is the question of sticking this label on them? There was no concept of minority, there was no right of minorities, there was no duties of minorities, no provision. Nobody, and they did not claim that they are minority. Yet, my lord, we are trying to project 30, my lord. So the two examples, my lord, with greatest respect, my lord, rather redound in my favor of my submission. Where you had a right, certainly it will continue and it can be elevated also. But if you had no right, and there was no concept of minority, and you never considered yourself to be minority, rather you rejected it. When it was told to you that you are minority, said no. Finally, just have a lot from the document from the transfer of power, very interesting. Page. Same volume, page 31, written submission. Para 8 at the bottom. I'm sorry, but underline minutes.
Where will you catch it, Mr. Dwivedi?
This volume 2J, which your lordships were having.
Page 31.
This is from the transfer of power.
Yes.
Page 31, para 8. I was therefore led to ask myself, what is this element in Muslim thought which finds expression in Pakistan? It derives, it seemed to me, from a revolt against the allied concepts of minority and safeguards. Experience under the Congress governments may have been the immediate stimulus, but the real motive goes deeper. Nor does it lie in the recognition that safeguards depend for their efficacy upon the presence of a third power to enforce them, a power which will disappear from the Indian scene with the coming of the dominion status. This is something happening relates to 1942. It lies more profoundly, though perhaps less consciously, in the knowledge that safeguards are designed to improve, but cannot radically alter the position of a minority which remains a minority. A Cinderella with trade union rights and a radio in the kitchen, still below stairs. It is against this whole combination of ideas that Muslim mind rebels. The two-nation theory, which transmutes the ideology of minorities, is thus more fundamental to their present thought than the Pakistan theory, which transmutes the ideology of safeguards. From this new outlook of Muslims, there will obviously be no retreat. My conversations have therefore indicated that it is misleading to approach the general Muslim problem in terms of the same phraseology as we use about the interest of minorities like the Europeans, depressed classes, and so on. Some new terminology is needed to keep our consideration of this problem on the right lines. Terminology which recognizes the problem is one of sharing of power rather than qualifying the terms on which power is exercised by a majority. And also, my lords, at page 38, both the Muslims and the ruling power of the time considered them to be a nation. They rejected minority, and we are trying to give that imprint. Finally, have the last page at page 38. The third line. That was the time, Lord, when Chiang Kai-shek was visiting India. When the INA forces had marched and reached Imphal, my lords. Third line, India is not one national state. It's two major nations being Hindus and Muslims, and 1/3 of India is under the princes. Unlike the case of industry and property, etc., my lord, where the rights were in existence and our constitution transmutes it into a higher level, protected it by fundamental rights under 1940. But here, something with which they are rejecting, which don't agree with, then by 30, my lord, and this is all past part of history. My lord. I can multiply number of documents, my lord, but this is just to give an idea, my lord, about what they were thinking. The person who is said to be the founder, his ideas, my lord, of separate nation continued to grip AMU. That is why, my lord, what was told to your lordship that when the president, or at that time Vice Chancellor Zakir Hussain, my lord, visited, he said that the future will depend upon how Aligarh looks to India. That was what was told to your lordship from the appellant side. Why was this said? Because Aligarh was with Pakistan movement. And a large number of students and teachers all migrated to Pakistan also. These are facts, my lord. I don't think, my lord, that it should be inconvenient to any person that this is being stated, but because we must face the truth and then see whether 30 can still be applied.
Yes, Mr. Reddy.
Now,
Okay.
kindly have the main volume, my lords, of my submission to H. Page 8. For a lordship's convenience, I will not read all of this, my lords, but this is from the Woods Dispatch. Which we have enclosed as R1. I have extracted the relevant portion.
Page
8, paragraph 11B. 11A is Macaulay's extract. That minutes of Macaulay is also enclosed as R6. Page 9 is the relevant portion, my lords. That is para 35. 11B at page 8. Kindly come to these. My lord, full documents are in volume 5H.
Where will you get the volume?
5H. Because the Hunter Commission, etc., is pretty thick volume, my lord, so we separately. All these documents in this written submission are separately compiled in 5H. Please turn to page 9. Para 35 from that document, Wood's dispatch. We shall be ready to sanction the creation of an university at Madras or in any other part of India where a sufficient number of institutions exist from which properly qualified candidates for degrees could be supplied. It being, in our opinion, advisable that the great centers of European government and civilization in India should possess universities
similar in character to those which will now be founded. As soon as the extension of a liberal education shows that their establishment would be of advantage to the native communities. Now, both the words founded and establishment are simultaneously being used, and the objectives are similar. Now, please turn to page 11.
So, para D. Between 1857 and 1882, no other university had been established. The Hunter Commission was appointed by resolution of Government of India dated 3rd of February 1882 to review the progress of English education made in India. Specific instructions were given to the Commission with respect to primary education, secondary education and colleges
to examine further involvement of private efforts under the grant in aid system. That is Hunter Commission report, para 10, page 626. It is noted in the report of the Commission that after the disappearance of British East India Company, the principles of dispatch of 1854 had been confirmed by the Secretary of State in the dispatch of 1859. In para 46 of the report related to the Indian universities, the same is quoted below. Now see at page 12, the last bold lines of this subpara D. This is regarding Lahore, Dr. Lickner.
The very prominent place, it is mainly an examining body, but exercises variety of functions for the promotion of literature and education. Its distinguishing features are that it owns its origin to other than state efforts, and that is designed to give special encouragement to Oriental studies. So somebody or the other obviously will goes and requests that now we need in the northwest frontier provinces, we need a university. There's no university.
So merely because somebody is requesting, contributing some little thing. Yes, ma'am.
Therefore, Lords, at that time, there was no policy. That's what I had submitted, and these documents show that up to the level of college, private efforts, grant in aid, otherwise there was no policy. Now with Lord, may I now move on to some 2-3 aspects of the Act only, because almost everything has been covered, so I don't want to retrace all those things. If your Lordship has volume 4C,
Volume 4C, Mr. Dwivedi?
4C, page 40.
In this case, who are the two nodal council actually? You're the. If you can just overnight, maybe give us a master index, like, we had in Article 370, with, act to be found in this, the documents you can give us a master index, then the judgments, so Basha, other judgments, which are the volumes. So it becomes easier when you are dictating in the end, or even to read it before the, as we go along. Put it in a plastic, or just on any paper, and we'll give it to the court master, so he'll circulate to all 5 of us. Yes.
Page 40, at the bottom, Mr. Shafi, who's introducing the bill, he is a member of the council, executive council. Sir, I beg to introduce the bill to establish and incorporate a teaching and residential Muslim university at Aligarh, and to move that bill be referred to a select committee consisting of the Honorable George Lowndes, the Honorable so-and-so,
Raja of Mahmudabad. There were 5 British persons in this select committee and 5 other gentlemen.
Raja Mahmudabad, Asad Ali, Khan Sahib, Shah Nawaz Bhutto. I hope not this name rings some bell. He is the father of the Prime Minister of Pakistan,
of Mr. Zulfikar Ali.
Bhutto. And there's something more very significant. All these 5 gentlemen ultimately were Pakistan supporters. And Shahnawaz Bhutto is the person who in January 1947 came from Karachi and became the Diwan of Junagadh, Nawab Junagadh. The Nawab himself, was holidaying in London. Mountbatten never, summoned him for accession like he was doing with all others on 3 subjects. He comes back, Nawab comes back on 11th of August and signs accession in favor of Pakistan. And along with his numerous dogs, he vanishes to Karachi.
Shahnawaz Bhutto continued there to rule.
In Junagadh.
From Junagadh. And when this accession happened to Pakistan, then there were 2 other principalities, that is Mangrol and Babriabad, which had been attached during World War with Junagadh. So they declared independence and acceded to India. When Shahnawaz Bhutto sent his forces to occupy Babriabad and Junagadh.
Then, cutting the other part of the story short, what happens is that Indian forces are sent, which take back and surround Junagadh. It is then that Shahnawaz Bhutto, through the sea route, vanishes to Karachi, and the Junagadh was regained. So these are
all forces, all these 5 gentlemen went there. In the negotiating team, M.A. Jinnah was also involved,
which was negotiating the bill. And he was one of the persons who said that now, since it's it's All India Importance University, therefore, instead of Lieutenant Governor of Northwest Province, it will be befitting to have the Governor General as Lord Rector. So this is one aspect which I wanted to point out to your lordships, that the British, in the scenario of Rowlatt Act 1919 and Khilafat movement, the discovery of oil in the Middle East and obtaining of the mandate in Palestine by the British imperialists, all these circumstances,
certain things were being done by the HMG and the Governor General, which is known to everybody. Drive a wedge.
You'll also find at the next page 41 bottom that this process began in 1911. The request. And it was granted only when they agreed to BHU in 1919. It took them 8 years to have that act. This is one aspect, my lords. The second aspect is, my lord, what is the significance of this office of Lord Rector? None of the universities which were created, established by the Governor General in Council, had this office of Lord Rector. We were told by the appellant's side, my lord, that
all universities have got visitors.
What is so great about it? There are visitors, there are chancellors, vice chancellors, there's some supervision, some regulation. So now I'm trying to, Lord, make an effort to apply these principles of 30 backwards and see what's the consequence. Can we say that it was established by the minority? This special office of Lord Rector and Governor General as Lord Rector was only in these two universities, BHU and Aligarh Muslim University. The second feature is that unlike the visitors, even in the acts passed subsequent to the independence under the Constitution of India, the visitors have a very limited power of supervising, causing an inspection to happen and giving a show cause,
giving some advice and directions. Nothing else. No visitor in no university, public or private, has got a power to make, approve, amend, modify statutes, ordinances.
So in contrast to the visitor, the Lord Rector has very wide powers. One, the first statute and the first ordinances are all made by the Governor General in Council. And no amendment can be enforced merely at the will of the court or the visitor's body, visiting board. It must get the approval. So ultimately, amendment can happen only at the will of the Governor General and nobody else, the Lord Rector. Statutes, the third, my lord, the statutes and the ordinances are the life and soul of a university. All universities function in accordance with that. The Aligarh Muslim University Act provides specifically that admissions will happen in accordance with the statutes and accordance with the ordinances. All policies in accordance with statute and ordinances. The court meets once in a year. Where is the control in the court? merely because the name has Muslims and the court has Muslims and de facto there have been Muslims. It's all fine, well, no problem. Nobody has problem with that. Muslims are also Indian citizens, you know, like anybody else. So if the majority of students there have been Mullahs are Muslims, so Muslim vice chancellor and can be appointed, but that doesn't mean that they have established, therefore we take it again back. This de facto is also rolled back to 1920 to find out the establishment. As I submitted, the main part of the establishment under Article 30 is the framing of the scheme of administration. Please mark the words, right to establish and administer. The right to administer has to be in accordance with the scheme of administration which happens with establishment.
But then aren't you drawing distinction between administration and legislation part? In your own argument itself.
No, there is no contradiction. With great respect, my lord. When you establish a university, supposing, my lord, let's take a hypothetical case. Today we establish a university, the law comes, X university is established, there is no framework. This is what happened in Yashpal. The appellants rely upon Yashpal. In Yashpal, my lord, by notifications under Act, my lord, universities were established, there was the shop. X university established in this shop, Y in that shop, and third in this house. No infrastructure, nothing. The court says no. If private people are establishing, then there must be infrastructure, there must be faculty, there must be all minimum rooms, etc. for where students will study. And until that is done, it cannot be incorporated. So what happened there was just incorporation of shops and houses and also on, and piece of open land university established.
Government, they said, may do that because government has obligations, constitutional obligations, it will establish, it has funds and everything. But one must know, there are no university shops. Therefore, when you establish a university, the scheme of administration has to be part of it. Who is going to be chancellor, who is going to be vice chancellor, how principal will be appointed, how employees will be appointed, how students will be admitted, how discipline will be maintained. So there has to be a framework. And that is what Justice Vanchu's judgment, my lord, Aziz Basha does. It looks into all the provisions and finds that the entire scheme of administration has been provided by the Act. Their role in the framing of the scheme of administration is very minimal in non-essential parts. Otherwise, BHU framework was there, you have to follow that. Some little changes were done because university became a central subject. So this rector, my lord, is a concept borrowed from the London universities, especially the 1858 Act where Scotland University was formed. From there, my lord, they took this. And rector, my lord, is considered to be a leader of the university. This is not a mere change of nomenclature that instead of visitor, we are having rector. And who is made, my lord? Lord Rector. That's added upon it, the Governor General, the supreme power on the soil of India. Nothing prevented the Governor General and Council from saying, my lord, that this MAO college is MAO university, as it is. And asking them to make some changes about visitors, etc. And just as today, the private universities are being formed. They could do anything. There was nobody to question, no judicial review. They don't do it. They keep the power and entitlement to establish university to themselves. And this is the Lord Rector, Lord, which is provided. Entire scheme is generated from having the source in the Lord Rector, the Governor General in Council, with the sanction of HMG. Before this was established, sanction was taken from the Secretary of State in London.
One last thing about this, my lord, is look at the court also, my lords. Volume 2B, my lord, is Solicitor General's submission.
The Lordship will not find the 124 members are the founder members. In the statute, the Act says members will be as per the statute. The statute has ordinary members and founder members.
Which page are you reading?
I'm just giving that one the statute number. Members wala kaun sa hai? Yes, kindly have statute number 8, which is at page 160. Class 1 is ex officio members. Class 2 is foundation members. Class 3 is life members, and class 4 is ordinary members. Now kindly come to the annexure, my lord, which is containing the names of the page 167. There's hardly any connect with the MAO college, its past students, past teachers, or those who were all over India, from even Indian states, Nawabs are members, retired director of public instruction. Almost half of them are in the service of British government in different parts of the countries, from northwest to Bengal and from Kerala to here. Not one person. Some of them are even judges, 46 judges have high court, district judges, magistrates. 79 is Nawab Justice Sir Syed Shamsul Huda, High Court, Calcutta. So all over the place. Item 81, Muhammad Ali Jinnah. People from Karachi, Punjab and all. 124 members in all. These founder members, Lord, are supposed to, under the statute, retire, like in Rajya Sabha, Lord, 1/5 retires every year, and so for at least after 5 years, 6th year, 7th year, 8th year, 9th year, like that, they will retire. So for 10 years, this is the founder members court. So they are Muslims, all right. Nothing to do with MAO.
They were all trustees of the MAO college.
All of them.
All of them.
Cannot.
Yes.
You show it.
Most of the facts stated are all wrong, but then
You place the correct facts. Now with this, my lords, the last submission which I would like to place is about stare decisis, my lord. stare decisis.
What do you have to say on stare decisis?
Lord, before this, just a reference, Lord, in one of the queries, Lord, of my lords, there was allusion to a legally positive approach, my lord, in this, my lord. Or the submission is, my lord, that legal positivism, my lord, does not involve any retrospectivity. It only, my lord, is concerned with infusing whether moral principles, my lord, can be utilized to interpret statutes, my lord. So various authors, in any case, my lord, the gods of legal positivism, my lords, are not at one. They are varied and in conflict. So very difficult to choose, my lord. However, my lords, the best approach would be of Hart, my lord, or Austin. But that also it's limited to infusing moral principles. Our court, my lord, I have given the judgments at page 9 of my additional submission, where the lordships have rejected the infusion of moral principles. However, my lord, today we are talking about constitutional morality, etc. So, at the highest, my lord, even if we have to infuse and inject the principles of constitutional morality and drawn from the provisions of the Constitution, it would be to interpret, my lord, the act. But we are faced with an entirely different question. Therefore, that approach, in my respectful submission, with utmost deference, my lord, may not be appropriate. With this, I come to stare decisis. Lord, my submission is, as Solicitor General has already indicated, Lord, this is a stand-alone university. The act, stand-alone act, creating a university of the kind it is. Judgment in Aziz Basha is statute specific. It analyzes if the particular act and comes to a certain conclusion. Third, my lord, is then the act was first amended in 1951 and then in 1965. Some individuals had come to the court. The Aligarh Muslim University never intervened. And it had no problem with Aziz Basha, at least on the judicial side. They may be trying to get changes through Parliament. Which obviously has to proceed on the footing that the judgment is good and we have to alter the basis, etc. And whether they have succeeded or not is a different question. But the Parliament also will proceed on the footing that the judgment is good and how to change the basis. Now, this judgment, my lords, being statute specific and concerning one university, has been implemented by the government for a long period of time. On the basis that it is not a minority institution.
On factual aspect, was there any reservation or preference given to the Muslims right from 1950 till 1981?
It's after 81 that this order was passed, which was challenged in the High Court.
No, I'm talking about from
No,
1950
not
till
my knowledge, but not subject to correction by the other side. Actually, it wasn't required, Milord, because 80% already they were admitting. So
No, but was there any preference being given, or by even if there was no preference being given,
no policy of reservation.
there was no policy of
That's subject to correction from the other side.
after 81?
After 81, this order came in 85, reserving 50%,
And
which was questioned. 2005. 2005, I'm sorry.
because what was said by, I think it was stated by them, preference was being given to the schools which were affiliated to the AME. And they were giving preference in admissions in the college itself.
So not perhaps in a formal way, but yeah, they were controlling Milords, they were principals and all those, so therefore they were admitting that way. That's what de facto submission is, Milord, that the vice chancellors were there, the principal was there, and so on. So now this judgment, Milords, has been implemented. Now, please see, Milord, when MAO asked the Governor General to establish the university, what was their contribution in the MAO college? Look at the establishment today, which was shown to your lordships. It's not the same thing. 74 acres of land. And now, Lords, it is having 1,150 acres of land. The government of India is in today's budget is 1,000 crores. There are today 17 halls, all subject to corrections. My learned friend will say it's all incorrect facts. 7-story building. So there's a complete metamorphosis. It's no more that MAO college. What are we looking at? What are we wanting to change? This judgment in Aziz Basha has no impact on any other university which were created before. This is a one standalone university. So what are we wanting to do today, Millers? I can understand that this judgment is creating havoc, Millers, with respect to minorities or something. There's no great public interest involved. Rather, all this money which has been invested by the governments in this institute on the understanding of Aziz Basha's position, that can't be taken away now. So we take back all those buildings, etc. You go and establish. Nobody has the right to a grant. There may well be, my lord, consequences which are adverse. So there's no public mischief happening. And I have, my lord, mentioned certain judgments. At page 56 of volume 2H. Para 53 to 59. भाई किसमें है? Kindly have para 58, Lords.
Which page?
Page 57, para 58. It's a quotation from Vaman Rao. The principle of stare decisis is also firmly rooted in American jurisprudence. It is recorded as a rule of policy which promotes predictability, certainty, uniformity, and stability. The legal system, it is said, should furnish a clear guide for conduct so that people may plan their affairs with assurance against surprise. It is important to further fair and expeditious adjudication by eliminating the need to relitigate every proposition in every case. When the weight of the volume of the decision on a point of general public importance is heavy enough, courts are inclined to abide by the rule of stare decisis, leaving it to the legislature to change long-standing precedents if it so thinks fit, expedient, or necessary. In Bernard so-and-so, Justice Brandeis stated that stare decisis is usually a wise policy because in most matters it is more important that the applicable rule of law be settled than it be settled right. 38, while dealing with the subject of stare decisis, Shri H.M. Sirvai, in his book on constitutional law, has pointed out how important it is for judges to conform to a certain measure of discipline so that decisions of old standing are not overruled for the reason merely that another view of the matter could also be taken. The learned author has cited an Australian case in which it was said that though the court has the power to reconsider its own decision, that should not be done upon a mere suggestion that some or all of it, the members of the latter court may arrive at a different conclusion if the matter were res integra, the Tramways case. The learned author then refers to two cases of our Supreme Court in which the importance of adherence to precedents was stressed. Justice Jagannath Das said in the Bengal immunity case that the finality of the decisions of Supreme Court, which is the court of last resort, will be greatly weakened and much mischief open to reconsideration. Much mischief done if we treat our own judgments, even though recent, as open to reconsideration. Justice Sinha said in the same case that if the Supreme Court were to review its own previous decisions simply on the ground that another view was possible, that litigant public may be encouraged to think always worthwhile taking a chance with the highest court of the land. Justice Hegde said in his dissenting judgment that the Supreme Court should not overrule its decisions except under compelling circumstances. It is only when the court is fully convinced that public interest of a substantial character would be jeopardized by a previous decision that the court should overrule that decision. Reconsideration of the earlier decisions, according to the learned judge, should be confined to questions of great public importance. Legal problems should not be treated as mere subjects for mental exercise. An earlier decision may therefore be overruled only if the court comes to the conclusion it's manifestly wrong, not upon a mere suggestion that if the matter were res integra members of so. Some other judgments are there, Lord, which I will not read on the same vein. Now, therefore, my Lord, in this case, I submit that there is greater public mischief to happen if Aziz Basha is even, my Lord, reconsidered and possibly overruled, Lords. Rather than, if this is sustained, it has no impact on any other. There is no other past act, my Lord, made by the Governor General in Council. So it has no other impact on trickle-down effect. Why we should not? What are we looking for, Lord, in this? No other benefit, and it's a judgment which has. We are now what 1968, 32, and 24, 56 years down the line. For a standalone case, which ultimately would result, Lord, in all this creation at the cost of public expense, Lord, to be handed over to. And lastly, my Lords, as I said, there is a distinction between established by, established for. In the worst case scenario, we look at the title Muslim University and the court Muslim. It would at the highest be a case where the Governor General is establishing the university for the Muslims. I have given in my written submission cases on by or under. By means directly by the provision of the Act. And under will be something like this deemed university. Section 3 UGC Act, where we apply with all my infrastructure, everything, degree colleges functioning, education level is high. And then the UGC recommends and government then sanctions and you are a deemed to be university. That is. And finally, this statute of recognition and statute of establishment. Aligarh Muslim University Act is a statute of establishment of university, not a case where the statute is merely recognizing some college which is already of the standard of a university. While establishing a university, the power that be can always infuse something from those people who are contributing. Sometimes they may be made trustees, sometimes they may be made some rector or something which is decorative positions, patrons, and so on. And even if we have to deal with the judgments, Patro, etc., they are all judgments, Saint Xavier, etc., which is the judgments which are of colleges and schools. So there's no question, none of those cases were considering, they have all noted, I have pointed out that Aziz Basha has been noted in at least half a dozen cases. And even St. Stephen's accepts the definition which has been accepted by Justice Vanchu. I have quoted that portion in my speech. Yes, sir.
Thank you, Mr.
I'm ready.
Thank you, Mr. Dev. Yes, Mr. Kaur. Yes, sir.
Hello, I'll concentrate on three aspects. One is the scope of reference and why it's important for your lordships to see that neither is Basha under review or in appeal. And I'll show the reference order in three crucial orders by never ever in 56 years, even remotely, the correctness of Basha on the issue of AMU being established and administered has ever been questioned. The only question in the reference order which said remains undetermined or is yet to be determined is only with regard to the conjunctive or disjunctive reading of established and administered under Article 30, subclause 1. That's the first limb of my argument. In the second limb of my argument, my lords, I will refer to the judgments because a question which was never framed is sought to be framed by the appellants in their written submissions to say there are internal contradictory findings in Basha. That's their question they frame. And then go on to say that this is contrary to various judgments of the Supreme Court to show that that is an attempt to unravel Basha completely when there is no contradiction with the 6 judgments that they cite. That will be the second limb of my argument. And the third will, of course, be 3 or 4 principal submissions established through by, was the act really seeking to overrule Basha? Was it a validating act? Just 3 or 4 crucial submissions I'll deal with in the end. Now, first of all, my lords, Aziz Basha was the result of 5 writ petitions challenging the constitutionality of the 1951 Amendment Act and the 1965 Amendment Act. The challenge was principally based on Article 30, subclause 1 of the Constitution. The petitioner's case in that matter was that AMU was established by Muslim minority and therefore the Muslims had the right to administer it, was their case. And they contended that the 1951 and 65 Acts took away or abridged the administrative rights of the Muslims, and thus the acts were ultra vires, Article 30, subclause 1. Now, the Supreme Court, my lords, distinctly on three different issues held. As far as administer and established is concerned, it was held, as also held in St. Stephen's later, that they have to be read conjunctively and not disjunctively. The second finding was that AMU was not established by a Muslim minority, but by the central government of the day. And thirdly, AMU was not administered by Muslim minority. The latter two, as I show the next few cases or 4 cases, never ever have been the subject matter of any discussion or being referred to a larger bench at all. It's all been about disjunctive versus conjunctive. Then came, my lords, the 2-judge bench decision in Anjuman-e-Rahmaniya versus the district inspector. Now, what had happened was the people who had set up the society, some were Muslims and some were non-Muslims in that case. So the issue which arose in Anjuman-e-Rahmaniya was whether protection under Article 30, subclause 1 will be granted to an institution which has not solely been established by a minority. That was the one issue they were grappling with in that judgment. And the other issue was regarding whether registration of a society under the Society Registration Act changes the status of the society from a minority institution to a non-minority institution. These were the two issues being dealt with in that judgment. It was in that context, they never disagreed with Basha, they never doubted Basha in any form. They referred it to 7 judges saying that we need to decide on the issue of essential conditions and ingredients of a minority institution should be decided once and for all. That was the basis of Rahmaniya. Now, as I respectfully submitted, my lords, nowhere was the findings in Aziz Basha regarding either establishment of AMU or administering of AMU ever questioned in this judgment. And they pertain to minority societies, not universities, that judgment. Then came TMA Pi Foundation, which dealt with the scope of minorities to deal with and administer an institution, and if aid is given, what are the nature of regulations which can be imposed, regulatory in nature, conditions that could be imposed. Therein, my lords, a question came to be framed, que Rahmaniya. And that question is the question 3 subclause A, which the reference order also refers to, and says that this was the question que Rahmaniya, which was framed in TMA Pi. And that question specifically, my lord said, would your lordships want to see that, or should I just read that out? Yes. What are the indicia for treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a persons belonging to a religious or linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? And then they went on to say this question need not be answered by this bench. It will be dealt by a regular bench. So the question was indicia and thereafter conjunctive or disjunctive. Whether AMU was administered by a Muslim minority, established by a Muslim minority, never ever questioned. TMA Pi again never questioned, in fact discussed, and then I come to TMA Pi, not for a second doubts what Basha said. Thereafter, my lords, while disposing of Anjuman-e-Rahmaniya, all that the judgment did, the 2 judges did, was that now TMA Pi is the law. All regulations, all orders, enactments, schemes, regulations will abide by TMA Pi. And if any question arises in future, it will be decided in the context of TMA Pi, and Rahmaniya came to be disposed of. Then came, my lords, the second reference order of 12th of February 2019, and that I'll request your lordships to please have once more, the reference order. Volume 3A, page 216. Yes. Volume 3A, page 216. This court in S. Aziz Basha and another versus Union of India, inter alia, has observed as follows. It is to our mind quite clear that Article 30 subclause 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the educational institution, it will have the right to administer it, if by some process it had been administering the same before the Constitution came into force. We are not prepared to accept this argument. The article, in our opinion, clearly shows that the minority will have the right to administer educational institutions of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it, and because for some reason or other, it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read, it gives the right to the minority to administer an educational. Educational institution, provided it has been established by it. We are of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution, even though the institution may not have been established by them. The two words in Article 30, subclause 1 must be read together, and so read, the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer it under Article 30, subclause 1. The judgment of the Allahabad High Court, which is under challenge in the present appeals, rejects the prayers made on account of the decision of this court in S. Aziz Basha Supra. The issue arising in S. Aziz Basha Supra was referred to a 7-judges bench by an order of this court dated 26 November 1981, passed in writ petition so-and-so, Anjuman-e-Rahmaniya versus District Inspector. The aforesaid writ petitions, that is writ petition number so-and-so, were heard along with other connected cases, TMA Pai versus State of Karnataka, by a bench of 11 judges, the judgment in which cases is reported as so-and-so. The question 3A, which was formulated for an answer in TMA5 Foundation, which coincidentally reflects the question referred by the order of this court dated 26 November 1981, passed in writ petition number so-and-so, is as follows. 3A. What are the indicia for the treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a person belonging to a religious or linguistic minority, or it's being administered by a person belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench, passed on 11th March 2003, which for reasons that we need not dilate, did not answer the aforesaid question 3A formulated in TMA Pai Foundation Supra. The said facts would show that the correctness of the question arising from the decision of this court in Aziz Basha Supra has remained undetermined. That apart, the decision of this court and Professor Yashpal and another versus State of Chhattisgarh and another, and the amendment of the National Commission for Minority Education Institution Act 2004 made in the year 2010 would also require an authoritative pronouncement on the aforesaid questions formulated and set out above. Besides the correctness of the view expressed in the judgment of this court in Aziz Basha, which has been extracted above. Ordinarily and in the normal course, the judiciary...
Just read this paragraph once again.
9?
Yes, for your argument. Just
9.
for first argument of yours.
9? Lordship wants me to read 9 again?
Yes.
That apart, the decision of this court and Professor Yashpal and another...
Now, what was Professor Yashpal?
Can I complete the para and then I'll answer that question? Then I'll answer that.
Okay, fair enough.
Versus State of Chhattisgarh and others, and the amendment of the National Commission for Minority Educational Institutions Act 2004, made in the year 2010, would also require an authoritative pronouncement on the aforesaid question formulated as set out above. besides the correctness of the view expressed in the judgment of this court and Aziz Basha, which has been extracted above. Now, my lords, the reason specific.
This paragraph refers to three things. One is the effect of Professor Yashpal.
Yes.
What did Yashpal deal with? And therefore, the issue which arises.
Right.
Second, it says amendment to the National Commission on Minority Education Act 2004.
Right. Right.
In 2010,
Right.
the second question.
Right.
The third question is with regard to correctness of the view expressed in the judgment of Aziz Basha.
Absolutely right. Now, let me answer that. So, what are the three things?
Basha expected above. Therefore,
No.
Yes.
Aziz Basha expected above.
Yes. So, the question is administered and established and administered, or established or administered is the Aziz Basha question. Why is Yashpal mentioned here? I put a question to myself. Yashpal is mentioned here because Yashpal had the provision under section 2F of the UGC Act, which said establish or incorporated. And they said in this context, it will have to be seen whether it is established or incorporated or established and incorporated. Because if your lordships will recollect in Yashpal, as Mr. Dwivedi also rightly pointed out, if you were to set up these one-room tenements all over as universities, all over the place, and then say, I have incorporated a university, that's a university, they said, no, you must have infrastructure, you must have facilities. So first establish and simultaneously incorporate. And that is why the word establish or incorporate, like administer and or incorporate or and administer and establish came into being. Most pertinent here is the amendment of the National Commission for Minority Educational Institutions Act 2004, because here the words used earlier were administer or establish, which by the 2010 amendment were replaced by administer or establish and administer. So that is why, keeping in mind that the question which in Aziz Basha remained undetermined was disjunctive or conjunctive, that is under Article 30 subclause 1, is it established and administered or established or administered? Similarly in Yashpal, the finding on established or incorporated, or should it be read as established and incorporated as in Yashpal? And more importantly, in the NCMEI Act, where the 2010 amendment changed the words from established or administered to established and administered, was the context that this had to be seen. My respectful submission in that light is that what your lordships are today being asked to decide on the basis of questions which have been framed by the appellants, not by the reference court, because the question they choose to frame, or one of the questions they choose to frame is that whether the decision in Aziz Basha is internally contradictory in its reasoning on facts and in law, contrary to the authoritative decisions of this court rendered nugatory by subsequent statutory changes, and contrary to the constitutional dispensation of Articles 29 and 30. Now, my lords, would your lordships, I'm not for a minute saying that a bench of 7 judges cannot frame an additional question or the contours cannot be decided. But would your lordships ever in these matters go into an appeal, go into a review of a judgment who has been settled for 56 years and never questioned at all in any decision, not once doubted on the two issues of AMU being administered and the AMU being established? On both questions, their findings never doubted. And the only question which arose was, is it to be read as or and that is what gets referred. And that is why the reference order in para 8 uses the word not in plural. It says the question in Basha. It doesn't say the questions in Basha, because the only question which arose was the question of disjunctive or conjunctive, not all the three issues, because Basha ultimately decided 3 issues: administer, establish and administer, or establish or administer. And St. Stephens, of course, followed that finding and said that it has to be conjunctively read, not disjunctively. So our respectful submission, my lords, also linking this argument to the last argument of Mr. Dwivedi on stare decisis is that would your lordships today, when neither does any court ever doubt the decision, and I'll go through those decisions that today or tomorrow when I again commence my arguments, then none of those decisions, whether Mother Provincial, St. Stephens, TMA Pi, A, their facts have no bearing on Bhasha at all. At all. Secondly, not one of them even remotely has questioned the correctness of Bhasha at any stage in any form. On the issue of administer and establishment of AMU as an institution, not by a minority as held in Aziz Bhasha. Recommence tomorrow morning.